All right, we're resuming the PowerPoint for chapters 13 and 14, slide number 55, talking about the courts here. Well, let's talk about selecting and deciding cases. Basically, the Supreme Court's primary responsibility is to decide precedents that will inform lower courts. All right, so a precedent is a judicial decision that is a rule for setting. Basically, it settles a case for future cases. All right, lower courts are expected to generally follow these precedents. And basically nearly all the cases that do come before the Supreme Court are those where one party lost at a lower court. And so basically they're appealing basically the final judgment by the Supreme Court. In order for the Supreme Court to take up a case, 4 of the 5 justices must agree to take up the case. It's called the rule of 4. And so if that happens, the court issues a writ of certiorari, which is a request for the lower court submits to the Supreme Court a record of the case. Actually 8,000 a year apply, less than 100 cases make it. So obviously it's very rare to actually even get chosen for this. It's also very, very expensive, and so you can imagine why many individuals stop. And so the court's job is not to correct the errors of lower courts, but to resolve substantial legal issues, okay? And so there must be compelling reasons for the Supreme Court to take up a particular case, all right? 3/4 of Supreme Court decisions reverse lower courts, okay? So again, these are the big cases. These are the cases that the Supreme Court considers ripe for some kind of a ruling to settle an issue. In other words, if there's all kinds of disconnects in lower courts and there's all kinds of rulings on a controversial issue where it's inconsistent in a number of courts or a number of districts throughout the country, that's when the Supreme Court is likely to step in to make a ruling. Going on to slide number 56, basically what tends to happen is briefs are created by the attorneys and they're given to the Supreme Court, and the attorneys are given basically the opportunity to have an oral argument. It's usually about a half an hour for each side, so you can imagine you better do it right then. Again, the other thing you need to realize is these attorneys that are appearing before the Supreme Court had better create a really, really good written brief, because obviously you're going to be able to say more in that written brief than you would in the 30-minute argument. And so basically the arguments are made, and then the justices go in conference, which is private. Okay, the public arguments are public, although there's a small amount of people that can actually go in and watch one of these. But then after that, the Supreme Court justices gather together and have a private conference where they basically kind of start tipping their hand as to where they might decide in that particular case. And then as they're doing that, the Chief Justice decides which of the justices he is in league with is going to write the opinion. And then if there's a dissenting justice, the senior justice will decide whether who's going to write the dissenting opinion and things of that nature. Basically, when the majority of justices decide on an opinion, it's called the majority opinion. Okay, there's 9 justices, 5-4 get you a majority, 6-3, 7-2, 8-1, 9-0. Okay, things of that nature. Pretty simple there. If you jump over to slide number 58, majority opinion is easy. There's many times when a Supreme Court justice will vote in the majority, but they come to that conclusion with a different line of legal reasoning. And so if they side with the majority, but they come to the conclusion with a different reasoning, they write what's called a concurring opinion. Okay, they agree, but they disagree with the reasoning, so they provide their own. And then, of course, if you are in the dissent, okay, you're on the losing side, you disagree with the majority, you write some form of a dissenting opinion there. Okay. And you can kind of take a look at that there. Let's talk about a couple of the myths associated with federal courts. First of all, it's something called the upper court myth, okay? And that's the idea that we think that lower courts are rigidly bound to Supreme Court decisions, okay? Again, the Supreme Court is establishing precedent, and again, the lower courts are expected to follow it, but they don't always follow it in lockstep for a number of reasons. First of all, the district court judges might misunderstand the Supreme Court's decision and deviate from it. Again, I encourage you to just look up a Supreme Court decision and go ahead and read it. Okay? When you read one of those, you're like, oh, that's why they were having a hard time understanding it, or they might have misunderstood it. You know, sometimes these Supreme Court decisions are 100 pages long, okay, packed with all kinds of legal reasoning and references to the Federalist Papers and all kinds of things like that. And so they can misunderstand it. Second of all, the facts of a case before a district court are seldom identical to the case that the Supreme Court decided on. So they're going to kind of misconstrue it. Third of all, there are ambiguities or unaddressed issues in Supreme Court rulings that give lower courts flexibility. Again, just because the Supreme Court rules on an issue, a lower court will hear an issue related to that. But again, the cases are not, one for one here. There's disconnects there. So that causes differences. And then fourth of all, most federal cases end with the district court's decision. Okay, the losing party decides not to appeal. Why? Because many times it's so expensive to keep going. Or why their attorney may have told them, listen, I don't think you're going to win. You can do that if you want, but you're going to lose. Okay. The other issue is that they don't appeal because, again, if the Supreme Court takes 8,000 cases a year and they only take less than 100, the likelihood of your case being taken is very, very slim. Okay. Then there's another court myth, okay, in opposed to the upper court myth, is something called the federal court myth, okay? And this myth holds that the federal judiciary is more important than state and local courts, okay? And that's not accurate as well. A big reason why, again, I'm going to go through all four, but think through our system. We've got a federal system. So it provides for a federal system of courts, and it also provides courts at the state level, and the Constitution gives autonomy to state courts to basically make their decisions and to adjudicate without the federal government reaching its paws in and changing or striking down a lot of what they do. Now, it can happen, and again, if it's dealing with issues related to the Constitution and in particular the Bill of Rights, then you might see that. So anyway, federal court myth says that federal court is more important than state courts. Number one, the reason that's not necessarily true and it's a myth is 95% of all legal cases are decided by state and local courts. Again, the federal court system is not set up to handle the 95% that it doesn't see. Okay, number two, most cases arising under criminal law are defined by state courts and local ordinances, or state legislature and local ordinances. Okay, in other words, shoplifting is not going to become a federal crime because shoplifting is a violation of local law or state law. Third of all, nearly all cases that originate in state and local courts tend to end there. Okay, federal courts don't come into the picture because the case does not involve a federal issue. Okay, easy to see this in divorce courts. Okay, divorce cases are never going to get to federal courts because, again, they don't deal with federal issues. The losing party cannot appeal to a federal court because, again, there's no violation of federal law. Okay, again, custody disputes and things like that, again, those are addressed at the state level. And then fourth of all, legal and factual determinations of state courts can bind the federal courts, okay, which is a clear contradiction of the federal court myth. Okay, in other words, the federal court tends to limit itself to the federal level, and the state courts tend to limit themselves to the state level, and generally both the federal courts and the state courts are perfectly happy to stay within their own sphere. So again, that's the federal court myth. Moving on here, we're going to start talking about the nature of judicial decision making, and I'm going to kind of resume that in the next lecture.